navigate that very easily. Further, there's another scenario which comes up quite often kind of with a will, and that's when it's a copy or if it's more than 4 years or if it's both. And certainly all three of those come together. So what I'm going to start with is I'm going to start with kind of the main statute here, and hopefully everyone should be able to see. So I've got Chapter 202 pulled up here, and we're going to go to 056. 202.056 is the service statute. Well, that's the waiver statute. One second. 053 and 052 rather. So 051. Maybe I'll get it right here. Here we go. So generally in an heirship, you're going to, the default rule is that you serve them by qualified delivery method. I think that the standard practice in Texas, I mean, really, if we're doing an independent administration, we're going to have waivers because everyone's going to be alive, everyone's going to sign, right? So that's kind of the default. Now, this 202 takes you through some how to serve people. If their addresses are known and their names are known and ascertainable, then they must be served by qualified delivery method. This again is a must statute. You can see it here. So that's the way that it has to be done. Unknowns, okay, are served by publication. And then if you were just doing this statute needs to go away. This is a statute that says that heirships have to be posted unless they're published. Every heirship gets published because you have to have a publication for the unknown heirs. There's a attorney general opinion on that. So this statute is defunct by the other statutes. So you don't need to do that. Anyway, so, generally use qualified delivery method, but if someone is deceased and they survived, so they're an heir, but now they're deceased, you can't really serve them by qualified delivery method. A court's not really going to let you do that. So the way that we fix this is, I got involved and we got a statute passed in last session. And the statute helps us fill the void. So here in 51, and this is a good statute to refresh if you're not on it very often, but kind of tells us how to serve different ways. So there's a personal service by mail and private delivery, how to do posting, how to do publication, if someone has an attorney, and this one really needs to be rewritten too, because this one still says if they have an attorney, you're supposed to serve them by qualified delivery method, and why we wouldn't just e-serve them, it would be enough. Doesn't make any sense. So that needs to be revisited, but that's for another day. And then on when you have to serve a personal representative or receiver, but this one is the one that's kind of govern how we handle post-deceased heirs. And this is a new statute. And this is 51.057, service regarding deceased person. So anytime that you have a post-deceased person, you should pull up this statute and look. And it kind of makes, I think, a lot of sense, mainly because I wrote it. I think that it makes a lot of sense, but it starts off and it says it's another must statute. So there's no discretion on the court here. If someone dies post-deceased and they've got a personal representative, serve the personal representative of their estate. And if they don't, if the personal representative's been discharged, if the independent executor has filed a closing report or a notice of closing, or there was a no administration ordered, such as a muniment of title, or the court finds there's no necessity in a judgment declaring heirship, or the court approved a small estate affidavit, which is technically also a finding of no administration, then this says, then don't serve the post-deceased person, see through their estate and serve their distributees, okay? Which kind of makes sense. That's what you should do. Next, if there's no court order determining the distributees of the estate of the deceased person, okay, who survived the decedent, and there's no personal representative appointed, then the citation or notice must be served on the unknown distributees of the estate by publication in which the probate proceeding is pending And if known to the applicant, in this case, the county of the last resident of the deceased person, if that residence was in a county other than the county in which the proceeding is pending, that means if someone dies, the decedent dies in Harris County, they have a kid who survives and then dies, they also live in Harris County. That's one publication in Harris County. Okay. If the kid died in Fort Bend County, probate's in Harris, then you have to do one in Harris, one in Fort Bend. If he had two kids, right, and one lived in Fort Bend and one lived in Brazoria, probate is in Harris, then you can do one publication in Harris because oh geez, and I didn't look up the rule, but there's a rule of civil procedure that says you can put multiple people on a single citation for publication. Don't let the clerks charge you one by one. They'll try to do that. Don't let them do it. Make you put everyone on one. So in Harris County, you'd have one citation for the unknown distributees of both children, and then you would have to do one in Fort Bend, one in Brazoria to catch that county, other than if it's not the county of the proceeding. And then lastly, about the statute, and here's looking at you, Travis County. If you serve someone this way using the statute, the court can appoint an ad litem to represent the unknown distributees. I know that's in there just for certain judges that wanted the option to do that. I know Judge Herman will almost always appoint an ad litem in a case like this. So you're going to get an ad litem to represent the unknown distributees. I do want to point out some of the technical aspects of doing this. The clerk or the court, because they're unfamiliar with this, and because of how we used to do it, right? When there was no guidance and we weren't really thinking about it, the court will encourage you wrongly, and the clerk will encourage you wrongly. And now I've even had the publisher try to encourage us wrongly that it should be that you serve the unknown heirs of the person who died. That is not correct. The statute is very clear on whose service must be made on. It's the unknown distributees. That was a deliberate choice. Distributees is a defined term, again, in the Estates Code, because in the proceeding that we're in that probate, it's not for the court to determine whether that post-deceased heir had a will, whether they died intestate, who their heirs could be or not, who the beneficiaries of the will, whether their will is valid or not. It's not on them to do any of that. The best way that we can give notice is to say, hey, unknown distributees, you better come forward. So if someone has a will, someone knows they died without a will, whatever, they need to come forward and file an appearance and do what they have to do to protect their rights. And if they don't, they're going to be considered served. There is, so that may happen. You may get pushback on that, or they may say that, and you may have to point the court or the staff to the citation, to this statute to say, no, I did the citation correctly. The statute is very clear. It says to the unknown distributees. That was extremely intentional, so that we make sure that we capture the right people. So this is one area. We talked about heirships, and I'm going to go through an heirship. There's another area where this comes up quite frequently, and it's in 258. Okay, so 258 right now is kind of talks about all the citations when you probate a will. So the first part of it is for regular wills. That's normal. That's just the regular posting. The next one is when there's a will not produced in court, and then the next one behind that is when there is more than 4 years. In both of those cases, both of the statutes, and this is also, I'd love to rewrite 258 to unify this in language and in application. But right now, it's kind of interesting the way it's done, because one, it says that if they are, it has to be personal service for citation. If their addresses are known and their names are known, if you know who they are and you know that they live in the state, it has to be personal service. And then by publication, if their names or addresses are unknown, or they're transient persons, or they're not residents of this state, that is to the unknown heirs of the testator. But a post-deceased heir is known and they're not the testator. So sometimes I've had some court push back on this statute and on the more than 4 years and say, well, this talks about the heirs later on in 258.051, notice to heirs, all of that. Those are the testator's heirs. A post-deceased heir, that is an heir, but you have to, we're trying to serve that person because they're now dead. So that will be to the unknown distributee. So don't get thrown off by that. In TXdocs, we will kind of get to that. There is a letter that we just released to send to the clerk. When we request citation on these, we send a letter and we're very clear. We will say, so like we don't request citation on post-deceased heirs like with the initial filing, like you would for everything else, all the normal stuff. We let it get filed, we let it get accepted. We send a letter and we will say, clerk, we want citations by publication on the following people. And we will put the unknown distributees of Bob, the unknown distributees of Sally, the unknown distributees, whatever. And then if it's like that, we may be sure to say, if it's a new county we're not used to, we may say, we'll only pay for one citation because all of them should be on one citation. So don't be afraid to get really specific with the clerk. And honestly, I feel like the clerks are more than happy to accommodate that. If you tell them exactly what you want, they can do it. They have a book. I found this out. They have a book of citation formats. I don't know if the unknown distributee one is in there, and they will sometimes call and say, did you mean to do this or did you mean to do unknown heirs? Because they know how to do the unknown heir ones. Me and my staff, we just tell them we meant distributee, but you feel free to use the heir one because that one is in the right order, and just go ahead and put unknown distributee instead of heir and it'll be perfect. So you can do that. There's also another interesting part of when it's more than 4 years, and it's 258.052. This is an ad litem appointment statute. This is different. This is an ad litem to again, and this is for the testator's heirs. That's different than the ad litem that could be appointed in 51.057, which would represent the unknown distributees of the post-deceased heir. So again, when you're dealing with this, I think it's really great to come back to these statutes and look. And so, because the court staff, they're dealing with a million things, you're dealing with a million things, your staff is dealing with a million things. So come back and get really clear and don't let them kind of talk you into stuff that you don't really want or need in those moments. The only time, there should be someone to represent the heirs really, I think, is if you say, well, we know he had John as a son and we can't find him. We don't know if he's alive or dead. That's different than you saying, well, John died, a month before we filed probate. That's, 057. If you say you don't know anything about him, we had one once where it was a lost will, but the son, we had witnesses of someone who saw the son and he said he was going to Mexico on a backpacking tour, and then they've never seen him. They hadn't seen him in 12 years, so we didn't know what to do. So we got an ad litem under this for this kind of action. So anyway, so that's kind of a really broad overview of the why and the how and the reasons why we do all of this. Now I'm going to get into, we're going to do some drafting, and I hate to say this, this is going to be fun because I did not test this before I did it. So, and I'll tell you what I mean is that I did not, I'm going to draft 2 different case types, all from the same answers. It should be fine, but if it's not, we'll find out. So anyway, so I'm going to start on a simpler case here. So I'm going to do this application, and I'm going to go through it really quickly. We call it a DHIA. In my office, that's a dependent determination of heirship with an independent administration. So I'm going to draft all of these. And again, if you may have seen me do this really quickly. Oh, wow, and that's really old. I'm not going to select the oath because I'm going to do something different later. Let me make sure that's right. I'm going to come and grab the new declaration because we don't use the oaths. So I'm looking for the declaration of the administrator here. So I'm gonna tick off that one. And I'm gonna go through and create these. This should be pretty quick because this has been done. So our decedent dead Dolores is here. And I've got information. Again, if your clients use intake, this would all be here for you. I'm gonna move kind of quickly, so don't get too freaked out. There's the death, all of that, that's here. This one isn't here. This is actually a new section that we recently added to help you if you want. This is to show if you want to, technically when it's an intestate estate, you do have to plead and prove with evidence that there is a necessity for administration. You do not have to prove that when there is a will, by the way, but anytime you're asking for an administration without a will, you have to show that there's a necessity for that. We kind of put in some pre-made choices for you. So I'm going to say that, we want to settle some debts. So, okay. I also want to say this is not more than 4 years. I didn't do that. Okay. So, here we go. So this is the heirship tree, and I have some people in here. So Dolores died, leaving a surviving spouse who's obviously alive, one alive daughter. Dolores died in 22, but you can see that the other daughter, Sally, I put it in right here, died in 2026. So this is a post-deceased heir. So you've got the heirs are going to be Sally, and daughter, Deidre, but Sally is post-deceased. So we're going to go through and do this. And her daughter is going to be the one that's the applicant because dad is too upset and can't do it. So here we go. There's the child. Okay, so information for Deirdre going through. So I'm going to keep building. I think there is another webinar of me building where I explain some of these choices maybe more slowly. So sorry for that. But I just kind of want to show you how we handle the post-deceased issues in this one. In Harris and really everywhere, and I haven't got any pushback. We generally just do unsworn declarations on everything with electronic signatures. We're going to ask for an administration. Okay. So almost done. This is for the judgments. There's the ad litem. I don't know who that is, so we're going to put that in. See. I'll keep going through here. Okay, so this is heirs filing waivers of citation. So obviously, sibling Sally is dead now. So she's not going to file one, but the other two are. So they're going to get waivers from them, and then we're going to have to perfect service on them. And again, for 202 or 202 waivers, same thing. Daughter, surviving spouse, going to sign waivers. Okay, so we're done. So we'll generate all of these documents. In my office, I know I say this every time, but I mean, our practice is we try to minimize drafting. And what that means is that I'm going to download all of these. What that means is that we generally try to draft in as few steps as possible. So we try to draft as much as we can, and then we can come back and draft more later if we need to. So we often are drafting a lot of documents like this. And we file generally, like for an heirship in Harris County, I will tell you there's generally 9 lead documents because we have all the witness proofs, the client's proof of death, both applications, the motion for ad litem, the oath, and all the order. We have everything except the judgment declaring heirship usually. So we can file all of that in the initial filing in Harris County, which is super convenient. All right, I'm going to switch over and I'm going to open. Really, I just want to look at the application to determine heirship so that we can see this really quickly. You should be able to see this now. I was accused by one of my friends of having a special version of TXdocs that I use that is not available to everyone. And I told him that that is kind of true because I do have a test account that has extra stuff in it, but my office uses a production regular account. And if you, he said that it's because my stuff, his stuff that he got out of TXdocs didn't look like mine. Everything that you see, by the way, you can edit in the format wizard and set up like firm-wide kind of settings for how all of your documents look. So the default, I think the modern style, if you choose the modern style, which will change everything to modern style, looks like mine, but you can customize it and make it look however you want. So I don't have a secret version of TXdocs. We just spend a lot of time configuring how our documents look because that's something that's important to me. Anyway, so here's the application to determine heirship. And I'd like you to see this chart because this is another post-deceased issue, and you can run yourself ragged fighting with the staff attorney on this. Here are the three people. Now notice Sal and Deirdre are alive. Notice also that TXdocs does all the math and all of this for you. You don't have to do any of that if you don't like math. I like math, but I know most lawyers don't. But here's Sally down here. And see what it says? It lists her as an heir because she is, and then it says deceased, but it says but survived decedent. This is to cue us in that she's now dead. And it, and that's kind of important information. Okay. There are some courts, there is a huge disagreement. Some of the courts, I want to say even Travis County, Judge Herman prefers you to put, instead of it like this, I believe, and it's been a while since I've done it in Travis, I think he prefers it to be the estate of sibling Sally, deceased. Even though there's not an estate open yet, or there's, it's kind of unknown what's going on with that, but, there's that. But in Harris County and in most of the counties, most of the people prefer it to be like this, which is why we defaulted it this way, which is to show the person, show their name, their last known address, and deceased. You may ask, well, why do I need to have their address if they're dead? Because the statute 51057 says you have to serve them by publication in the county of the proceeding and in their county of last residence if it's different. So if I'm the staff attorney and I'm reviewing this, I can see, well, Sally lived in Houston, so there's only going to be one publication for her here in Harris County, and that's it. So that's how that's done. So this way you don't have to do much. It's kind of done for you if you can enter it in there. we're going to draft another one where it's more complicated. I'm going to get to that really quickly. I do want to come back to TXdocs though, real quick and show you the letter to the clerk. So we're going to assemble this new document, and under right here, you can shrink everything here, letters to clerk. There is letter to clerk requesting citation. This is a new letter that we just recently added. Generally, you would have a docket number. We don't have one right now, okay? But here it is. So the thing to be served like would be the app, if I can spell application to determine heirship, and let's say, well, it was filed today, which is what, the 11th. And we're going to do publication, and, we're going to do unknown distributees of sibling Sally deceased. Okay. And I can't, oh my goodness, I can't type today. So that's what we would do. We're going to build this really quickly just so you can kind of see it. Oh, download it. And let me switch over just so y'all can see this letter real quick. So this is kind of the default. It knows that we're in Harris, so these are updated by TXdocs and updated as needed. If they're ever wrong, let us know so we can update it. The cause number would obviously have been there, but this isn't a real case. But this is what we do. We ask for this, and then this is the person, how we're doing it. They have any questions, whatever. When you file this, you would e-file this as a request if that's the proper code. But no, I've seen actually recently where a county didn't have a request code. You had to use, I think, no fee document. But you just attach, the appropriate fees. The clerk will figure it out. And if they have questions, they'll usually call. But this is really handy. So you can use this, and if you had more than one, you could list them all out however you need to do it. And if you need multiples, you can edit this, of course, and say, well, I need 2 for Sally because I need you to do 1 in Harris and 1 over there or whatever. So that kind of gets you to the right place on that. Okay. Now I would like to kind of show you a little more, one that's a little more complicated. And I'm going to come over here, and this is kind of sibling Sally, the one we were just talking about, but I changed it up some. So what I'm going to do is I'm going to come back over here to the form set, although I'm not going to do all of these because really I'm only going to do the waivers and that for now. And we're going to switch gears here. So we're going to do this one for Miss Sally, who died. And if your client had done intake online, all of this information would have been done. Let's say she's born in 1979. Now she died in 2015, so she died quite a bit ago. We're obviously going to have a more than 4 years situation. But here's her family tree. So I've done some interesting things. I don't know if I can. Let me see. Well, I can get it a little bigger. So here she is here in the black. She has a surviving spouse who's still alive. She has there's her mom, dead Dolores, died before her in 2005. She gets a pre-deceased checkbox, and that's something important. If they're pre-deceased, you check that. If they're not, you uncheck it. It will help. It will automatically guess if you put in a date that's before the date of death. It'll click it on for you. But if for whatever reason something changes or you originally entered the wrong date of death, you may want to come and check and make sure this box is checked or not. Because if it's pre-deceased, then for intestacy, you skip over them and go down to their descendants. But if it's post-deceased, you have to stop. You can't look beyond them because there are no heirs beyond. They are the heir. There's no one beyond them. So they have a surviving dad, Sal. There's Deirdre, who is a whole-blooded sibling. And then we have Sad Sam over here. He is a pre-deceased half sibling on the mother's side. So the other parent, through the mother. So the shared parent is down here. Dead Dolores is the shared parent. You can see the line there. And he pre-deceased, and then he has 2 children. We'll call them Nibbling Ned and Nibbling Nancy. Here you can see Nibbling Ned just recently died. So Nibbling Ned is a post-deceased heir. Okay. And then you've got Bully Bob, and he's probably going to be problematic. He shares the parent with surviving Sal. Okay. So you've got a spouse, you've got a whole-blooded sibling, you've got collateral heirs of the half-blood, both through the mom and through the dad. Now, I'm going to take a time out and tell you all an interesting story that recently happened. I was recently called about a situation that was very similar to this and about what the distribution would be. This does not seem complicated to me, but the person I talked to, and I have actually had this issue with other lawyers and one judge in particular, who said that the heirs of sibling Sally would be the spouse, the father, the whole-blooded sibling Deidre, and only this part of the tree, I guess Nibbling Ned and Nibbling Nancy. And that Bully Bob here would not be an heir because he's a child through the surviving parent. And so those half siblings don't get it. That essentially only half siblings through the deceased parent inherit. That is not in accord with Texas law, one. That is not in accord with the plain meaning of the statute, plain reading of the statute, which says that when someone's survived by a parent and siblings or descendants of siblings, that one share is created for the parent and the other share is divided among the siblings. It doesn't say divided among the descendants of the deceased parent. It says divided among the siblings. Anyway, what's interesting about this is not that it does seem to cause some confusion for people. Of course, all of these people here are heirs, including Bully Bob. And yes, technically, he will take as a half sibling and get half as much as Deirdre. Him and this Nibbling Ned and Nibbling Nancy will get the same amount as Bully Bob. They're both collateral heirs of the half-blood. But Deirdre will get twice as much as them. All of these people are heirs. And yeah, it could be that he takes twice, but maybe not. I mean, his dad may not leave him anything. He may leave a will and not give him anything. Yeah, so I can understand the rationale. But what's interesting about this story is I asked Copilot about it. And Copilot very convincingly told me that I was wrong and that Bully Bob would not be an heir. And I guess it was reading about moieties later, and it was trying to use that moiety logic to apply here. That's not the plain language of the statute. Anyway, when I tried to convince it or ask it to give me case law, things like that, it couldn't really do that, but Copilot would not change its mind. I did ask Gemini is the other one that I asked, and Gemini actually got it completely correct the first time, and actually I thought did a really good job of quoting the statute and saying this is what the statute says. Statute says one part goes to the parent, one part goes to the other. I also double checked by asking. I worked for Professor Beyer when I was in law school. That's what I did the whole time I was in law school, is work for Professor Beyer. I also let Professor Beyer on it and made sure that I wasn't crazy, but I'm not. So anyway, that's an interesting, I think, aside and something to think about when it comes to that, and don't let people get you off topic there. Okay, so we've got back to these post-deceased heirs here. So we've got all of these heirs. We've got one post-deceased, which is Dibbling Ned over here. But mainly, this is to kind of show you what this will look like. So I'm gonna fly through here. I haven't built this one before. So, no will. So I have to be a little careful. I want to tell you this too. This is another new feature that we've added recently. Helpful options for proving heirs. Anytime there's collateral heirs, you can check this box. And it even says, this is helpful to courts when there are collateral heirs. Collateral heirs are anyone that's like off to the side of the decedent in the tree, not descendants. And what this will do is this will add in more language and explain the family tree more, because sometimes it's confusing for the court if it's like, oh, well, the heirs are a spouse and a great nephew. Well, how is the court going to verify that? So this would add in language like they were survived by these parents, or their parents predeceased them and they had a brother and the brother, or whatever. It'll explain all of that so that the court can make sense of the ultimate chart. You know who else also appreciates this is the ad litem. And speaking about this, if you go back to that family tree, you can print that and save it. You can print it as an image and you can print it as a PDF. It's not always the prettiest thing, and I rest assured, if you know anything, it's complicated to automatically print that. Just have the computer generated. It's difficult, but even regardless, it's still extremely useful. And especially you can take an image of it as a picture, and it actually does the whole thing as a single image, so you could pull it up on your computer and kind of move around and look at it. It's really helpful to the ad litem. It's helpful to the court. Anytime anything's funky, we attach that as an exhibit to our application to determine heirship and file that. And I have had judges, court staff, and ad litems all thank me for including a family tree because it really helps. So that's just another, you can do this, check this box, and do a picture of the family tree. You'll really be helping out. Here are the 202 waivers. So again, everyone's going to do, we'll just say everyone's getting one, but nibbling Ned, because he's the post deceased, he can't sign a waiver. Anyway, so all of these are done. So let's pull up the application to determine heirship real quick, so you can take a look at that. It's going to be similar to what we had before. Okay, so you can see we're missing some information, right? So someone didn't do a good job of filling this out. But if you look, here is the chart. So father here gets 1/4 of set right when someone dies married in Texas without children, but with a spouse, the spouse inherits all of the personal property and all of the community. So all of the personal property, all of the community, and they retain their own. They get half of the separate real. The other half gets split into two parts, one to the surviving parent, and then the rest you can see here. Here's Bully Bob taking half as much as the other full-blooded sibling, and then Nibbling Ned and Nibbling Nancy getting the same as Bully Bob, but split in half because they have to share their parents' piece. So here you can kind of see a more complicated tree. Again, all the math is done for you and correctly, which is really great. Again, you can see here, deceased but survived decedent. So it's very clear, here's your post-deceased heir. So that's the person you would need to do publication on under 057. All right. So this is very, I think in the grand scheme of things, this makes things very simple, especially if you and your staff can really get good at kind of mastering that family tree input. And I have even just, one of my staff members who mainly answers the phone, you can actually open, and I'll show you that right now, how we do this for her. She doesn't really draft much, but she can do this. She can select the case, go to practice tools here, go to probate, go to heirship tree. So make sure you're on the right case. You can open just the tree. And sometimes we just have her call and get like, hey, they forgot to put the address. They forgot to put date of birth. They forgot whatever. And we just have her call and just manually pull this information. And you can't see what I'm talking about. 1 second. I just realized I left that off. Here you go. Okay, I'm going to go back. I'm going to cancel. Don't save my answers. So when you're here, this is where my staff, she can just come practice tools right here and then go to probate tools and heirship tree. You can edit just the tree. So this is convenient for your staff, can come in, enter information about these people if it's missing, type in a birthday, whatever. And then when they're done, they can go down here to save and close. And then now it's maybe ready, the attorney or paralegal can come back and draft whatever they need to, whatever the application is or whatever, and all that family tree information will be in there. There's one other document I want to look at on this before we finish up with heirships here, and it's the affidavit of service of citation, or the certificate of service. I normally do a certificate. I don't make my client sign it because I normally did the waivers. I normally did publication. I normally did whatever. So let's go and build this really quickly. So this is what you have to have. This is jurisdictional. Can't do this. Looky here. This is what's normally going to happen. You're going to say, well, no service appeared in court. That's usually your client. No service, waiver of notice. That's usually everyone who's living. This is, assuming that they don't all hate each other and are fighting. And then otherwise it would be mostly qualified delivery method. And then here it is, service on a deceased person under 51057B. So here's what we can do. So we can say in this one, I'm trying to remember what his name was. I remember it was Nibbling Ned. Yes. And then here's the county and state. Remember, he lived here in Harris County, Texas. Next. Okay. Persons who waive service. That was I think that was, well, I don't remember if it was surly spouse or surviving Sal, or I can't remember, but you'd have to go back and look. Nibbling Ned and then Burly Bob say um, Bully Bob. There we go. And then who made an appearance in court? That's your client. Deirdre. Well, now I can't remember what her name is. See, you do it, I do it too much and you can't remember. Oh, yeah, Deirdre daughter. Anyway, I don't know why it's not. I must be spelling it wrong. Anyway, so you do something like that. Anyway, you get everyone in there. So let's and if they were minors, you could tell that were minors and put in the parents' information because like when they're under 12, I think it is now, they can do their own. So sorry, the Zoom screen is in my way. I'm gonna open this real quick just so we can take a look at it so you can see, because this is something else you would use. Let me share it back. Here you go. So here's a certificate of service of citation. Remember, this is what you have to have before you can have a hearing. So anyway, it lets the courts know, hey, I did this person by publication under this statute. These people did waivers. This person, right, they didn't make one because they already made their appearance in court. And you may have other ones that made appearances, or you may have some that signed waivers. You may have had whatever. But this, you can do all of this fairly easily and quickly using TXdocs, and it has options to handle all of those post-decease issues. It's a really great way and a clean way to do it all very easily. Now, I know we're getting lower on time, but I would like to come back and just change this really quickly and show you something else. I think that comes up quite a bit, and that is for a will. So I just want to do a will application to show you how that would come up. So here's an independent and you know what? I'm actually going to do it as a muniment of title because I feel like we'll just do it. I think it's more than 4 years anyway. So we'll just do the application in the order real quick. This is the part I didn't try because we already built it as a intestate estate, and now I'm doing it here. See, I knew it was going to be weird. I don't know if that's even. I'm just making stuff up at this point. But they died in 2015, right? So this is really, we've worked on this, adding reasons why you can be the applicant. We'll say that she's also named to be the executor. I don't know, but we'll go through here. She's a resident. We'll just say the will was written in 2005 and it's self-proving and all of that. We're not going to do anything on that. And we'll ask for a waiver. Because it's more than 4 years, and I will show you this, I would highly recommend that you keep this box checked. This box includes the necessary waiver that's in 258.051. And I'm going to show you what it is, and I can show you the statute later. I put it in here because the clerks frequently get the citation wrong. So if you serve someone personally, which is what the statute requires, the citation will not have the required admonishment language that the statute says has to be there. So if you do this, it's in your application. So if anyone ever comes back and says, well, the citation didn't have the language, you can say, well, the citation was served with the application, and the application had the notice on it. And the statute doesn't say it has to be in the citation. It just says they have to get notice of that admonishment. So we included this in here because I kept getting tired of having to call the clerk, and we would realize after the fact that the citation was wrong, sometimes after we'd already served people. So here it is, more than 4 years. So you can say, I don't know, whatever reason they're going to say, like, hopefully not they forgot, they just realized, I don't know, whatever you want to put, or they found it under the bed. True story. Okay, so we're going to go through here. And if it were a copy, you could do that too. Now it's going to make us list the devisees, so we'll just put Deirdre in here, and we'll just put child, and then it brings up the heirship tree because it will include a listing of the devisees, but it also includes a listing of all the heirs who would inherit if there weren't a will. So we've got the family tree, and that's already been done for us. So we're going to go through here, and then the executors. This is executors who are not also applicants, but Deirdre, quote, is the executor and she's the applicant. We'll just say Bob and John, whatever, are the witnesses, just so we have them in there. Okay, asking all these will questions. Here we go, no verification. You see the order asked me if it was more than 4 years, but no default. So it puts language in the order. So here's all of this generated. So we'll download that, and then I will switch and show you the application real quick. Okay, so here it is, a more than 4-year application. You see it, it puts it in the title for you right here, more than 4 years after the death of the decedent. It gives all of the normal information. So who it is, who they died, when, where, all of that. Now, this is when you can see right here where it starts with devisees. This is where the extra information comes in. Here's the devisee in the will, and then it's heirs and possible heirs. So you can see here they all are, right? All the possible heirs that we put into the tree. And you can see right here, nibbling Ned. Oh no, don't do that. Again, deceased but survived decedent. So it cues the court in that they survived, sorry, but then they died after. They're a post-deceased heir. So this clues them in, and now you can do the service that you need to do. There's not a certificate of service of citation that explains that you served them that way. I would, bring it to the court's attention at the hearing, though, just to make special note of it. I've thought about making kind of a little certificate that you could file just to help clarify the record, because I do think it would be nice later on to see, oh yeah, they did do a return, but not yet. And then the last thing, this notice to heirs. This is just straight out of the statute. So again, and we put this little admonishment here because we felt like basically it's, we didn't want to say it, but the statute made us say it. So it makes the following a required statement, right? And this is the language that it says. It has to say the decedent's property will pass the decedent's heirs if the will is not admitted and the applicant may not be in default for failing to present the will, all of that. So this way, if it's in this application right here, and you get service on someone, then later they can't say, well, it was a defective service because it didn't have the required admonishment. So looking in here, this kind of has everything. And if it were a copy, it would be the exact same. I could have checked the copy box and it would just say, will not producible in court more than 4 years after the date of death. And it would have included this same extra information. Interestingly enough, 258 requires this information, the devisees and the heirs. That's required information when it's a copy. It's technically not required when it's more than 4 years, which doesn't make any sense. But we always include it because this gives, right, the staff needs a checklist. Here's their checklist of who better have service or waivers right here, all of these people. And the devisees, because in, like, for example, Travis County, again, Judge Herman has a standing order that you have to get the same waivers from the devisees of the will. So he requires the statutorily required service, of the heirs, but he also requires service on the devisees, which I don't really understand. Normally people generally don't complain about being in a will. They only complain about being out of a will. So there is that. So I think that is everything on my list. I don't know if there are a bunch of questions or not, but we can end a couple of minutes early. So
Absolutely, Joel. Let me first wrap up and then we'll do the questions. 1 second to share my screen. Well, first of all, Joel, that was fantastic. I learned a lot. That doesn't mean much, but I'm sure everyone attending also learned a lot. And the good news is that sounds like there's a lot of statutes that need some rewriting. So our attendees can look forward to not just new forms in TXdocs, but also some more clarifying statutes in 2027, second half of 2027, probably.
Yes, I have some reworks that are going to be submitted to the legislature. I will tell you, it is something that I'm super excited about because it's going to be, I don't know if it'll pass. There is no opposition from any of the statutory probate judges, but it will be wills by submission to allow courts to hear anything by submission, but specifically setting in a framework to allow applications to probate wills to be heard by submission only, without the necessity of an oral hearing. And also clarifying 256, 257, which none of us are doing right in the remote era, which says that all testimony has to be reduced to writing at the hearing and signed and sworn to in the hearing. We're not doing that. We're all having remote hearings and we're signing it and submitting it later that day or the next day. So we're going to rewrite that statute that just says all testimony has to be signed and filed within 3 days, just because no one is doing it in the hearing because we're all doing it remotely. At least in the bigger counties, we're all doing it remotely. So that hopefully those things will pass. That'll make life for practitioners a lot easier.
Well, good. Okay, so if you have any questions, please submit them using the questions box. Joel has been very gracious with his time and is getting ready to answer those questions live in a second. Just some housekeeping. If you've gave us your bar number, then we are submitting your attendance to the bar, so you don't have to do that. You are going to get a recording of this webinar tomorrow, and today you're going to get a certificate of attendance so that you can use that certificate to get credit if we didn't have your bar number. Last but not least, there's a short survey at the end of this webinar. It will pop up automatically once we close this webinar. Please answer those 3 questions. It will help us a lot. And then if you have any other requests for us, let us know. We're here to serve you, so we're always looking for ways to do that better. All right, with that said, Joel, if you wouldn't mind looking at the open questions, there's quite a few I see. And,
sure. Well, you want me to just jump in and start answering them?
Go right ahead.
Okay, I'm going to answer this one because it jumped out. It was a question about the publication citation, about having multiple estates or multiple people on a single citation for publication. I had to ask my paralegal Megan real quick. It's Rule of Civil Procedure 114. So you may have to give that to the clerk, but it specifically allows you to have like the unknown distributees of Bob, the unknown distributees of, whatever. Because I think once we may have had 10 on one citation. And in Harris County, maybe it was 15. I don't even remember, but it was so much, it was going to be, $1,500 or something to just get all the citations and service. It was ridiculous and then we forced them all to do it in one citation. So that is that. I hope I'm going to click answer live. I think that means that I did it. Okay. I don't really know. Okay. Let me see. Yeah, so I have a question here about the statute says only distributees served and not their heirs under 51057. That is correct, because if you it goes back to airships within airships. We do not do nested airships in Texas. And that's kind of the thing that I think gets people thrown off. But remember, every kind of the civil litigators sometimes cannot wrap their head around this. Every decedent gets one cause number. That is in the estates code. If you die, you get one cause number. This is why the civil litigators freak out when you try to file a bill of review in the same case, and they'll freak out and say, well, it has to be in a different one. You're like, well, actually, the statute says they only get one. So because there's only every decedent gets their own cause number, if we're in an airship and someone dies later and you try to reach through the court sitting in this part in the decedent's estate, it's not allowed and it's not appropriate. If John dies, it's not appropriate for me to see through John's estate and serve other people or serve John's heirs. For one, John may have a will, so his heirs are completely not interested in the estate, in the decedent's estate. But it's also, John may not live in that county, and therefore the court doesn't have subject matter jurisdiction and doesn't have personal jurisdiction, and certainly doesn't have, probates in rem. It doesn't have jurisdiction, because the estates code says he can't do that. If he's in a different county, that court's without jurisdiction to do that. That's why it has to stop. If it has to stop at the heir. The heir is the deceased person. Just because they die, they're still an heir. So we don't look through, we don't see through, we don't guess. We're not doing any of that. We're basically saying, hey, we can do that. Now, that being said, are there plenty of situations where it's worth your time or your client's time to maybe go and do an airship or get a personal representative appointed or do a small estate affidavit? I do that all the time. I've had a string of cases where we have a will and it's a copy, okay? And well, the copy was incidental. It was 002A, which means there was no independent administration provided. But one of the distributees, say one of the kids died, okay? And they leave kids. They have kids. They die without a will. We need consent of all the devisees of the will to get an independent administration. How are we going to do that? Okay. One, we may, if we know like John was a devisee and he's dead now, but he survived and then he died. We need consent. Well, what we could do is we could do a small estate affidavit, because say we know from the will he's only going to get his piece only 20 grand. So we do a small estate affidavit that says John died with a spouse and 2 kids, right? And then the court signs that order, that small estate affidavit. Now we can use that to bridge the gap and get 002A waivers to get consent in the original decedent's estate for independent administration. That's appropriate. And the court's not reaching beyond. The court's linking to a completely different cause number, a completely different case that was concerned with that post-deceased heir. So it's very separate. But I hear that all the time. I know someone else was saying they want service directed at the heirs of the person, but that's always bothered me, because they may all have wills, and then we're serving people that are completely not interested. So there's that one. Yes. Someone asked, do you request the clerk issue multiple citations for each known distributee, or can one citation be issued for multiple knowns? So the 114 statute is for publication only. So if they are known distributees and they're alive, then you have to go back to 202 in an airship, because if they're in the state, they must be served by qualified delivery method, or if they're out of state, they can be served by private process server. Or you can get a Rule 106 motion and serve them however the court wants. There's also a statute that says the court can require personal service in 202 if you keep reading. It's in the same service area. So when it's going to be personal service or something that's going to be actually delivered to someone, there can't be multiple people on a citation. And I think that's why the clerk and people get confused. You can only do it for publication that I'm aware of, because Otherwise, it doesn't make sense because whether it's qualified delivery method or personal service, you're like giving it to them, to the person, right? But in a publication, you're just giving it to the publisher to publish. So I don't think you can do multiples unless it's for publication only. That's the only time. And in that 114, if I'm remember, I don't have it in front. I don't have my rule book is over there across my office, but I'm pretty sure it's for publication only on that one. Let me see here. Or someone asked if there's forms for where husband dies first and then 2 years later wife dies and both leaves will. Yeah, I mean, there's not a specific form for that, but I will tell you, this is how I remember it. When in a situation like that, if you need to chain probates together, you always start with the last to die and work your way backwards. If you start with the last to die and work backwards, you'll have everything you need. And then if it's husband and wife, I would file wife first because she was last to die. I would always file wife first or the last to die first. And then I would come back once I got acceptance. I would come back and file the husband's, ask for it to be put into the same court, which they'll totally do as a companion case in Harris County. And then I would set them and run them together. They still get, again, go back to the estates code. Every deceased person gets one cause number. So you can't do husband and wife together exactly, but you can kind of run them, simultaneously at the same time. You could run them together that way. But there's no real form about that. It is frustrating. And just as an aside, it's frustrating because sometimes I tell the client, like, hey, you're gonna have to fill out 2 intake forms, right? And you need to, I'm always like, pretend you're doing it for wife, and then you have to open the other one and do it for husband. There's not a real easy way to like copy or mirror or clone those answers. That may be something that we could look at later, but it gets a little tricky. So oftentimes I just tell them it's 2 probates, 2 intake forms, same 2 processes. That's just the way you kind of have to do it. Someone's asking if a distributee is incompetent and they have an agent under a power of attorney, but no guardian. Yes, they can. I will tell you in my experience that now the power of attorney has to grant the right powers. Okay. So the agent has to be empowered with the right power to do it. But if they've got like a state beneficiary transaction power or legal power or whatever it is on the power of attorney, they can do it. I will tell you in my experience, every time I've done that, the court has asked to review the power of attorney in camera. So they don't want me to file it, but they've asked for me to like email it and let them review it. The judge has. So we always make it a habit. If someone's going to sign a waiver or consent via power of attorney, we're very clear. We edit that. That's not built into TXdocs, so it's just something we manually add in. It didn't happen that often, but it has happened in the past. We do that. We file it, and then we will email the staff attorney or the court coordinator and just say, hey, we had someone sign by power of attorney. Here's the power of attorney for you to review. And that's usually done the trick every time. Okay. Let me see. So someone's asking that their decedent died in 2018. It's more than 4 years. Left will naming mom and dad as devisees. The decedent had no kids and no siblings. Mom and dad died after the decedent, but before the probate. Will has no residuary clause, so we are going to do an heirship. Do we have to start hunting the collateral heirs? Well, no. I mean, you can probate the will. The will leaves everything to mom and dad. When you ask you're doing an heirship, I would hope that you mean you're doing an heirship for mom and dad, not for the original decedent. The original decedent, everything goes to mom and dad. The fact that they're dead now has nothing to do with what happened in 2018. When a couple of things about that. So, in Texas, property is owned by, well, unless it's owned by an entity, but we're not talking about entities. Property is owned by living people. So what that means is, and that's what the estates code says, and what probably was the common law before it was even codified, title transfers at death. So every time someone dies, and when I train my staff or talk to other lawyers, I mean, when someone dies, I'm like, it's a snapshot in time. It's just that singular moment in time that we're looking at in that probate. We're not moving backwards or forwards in time. We're stuck. So when that guy died in 2018, that's the snapshot that you're looking at 2018. And in 2018, mom and dad, the will said mom and dad got everything. So they get everything. Just because now in 2026 they're dead has nothing to do with what the circumstances the facts and circumstances that existed at the time of death in 2018. So don't get sometimes that's like a red herring that gets people out of whack. So I'm always like, go back to that date of death, go back to that snapshot, and only you have to put yourself, that's where the probate is frozen and stuck at. Now, for service and other things, right? If they die later, we have to handle back that, but that's only for service. That's only for due process reasons. For distribution and who gets what property, we always come back to that date of death and look from there. So in that case, don't fall for the trap of thinking, well, a devotee died, now we have to go hunt for their heirs. Then now you're nesting probates again, and we don't do that in Texas. That's a big no-no. So we do know on that. So don't do that. So I did that one. All right. Let me see. Someone's asking, not really related to this, but I will tell you the answer. What application form is used to appoint an administrator for an open estate where the will's been admitted, the appointed executor died, and no other executors listed in the will? If there's an agreement, okay, you can do 002B, which is independent administrator with will annexed by agreement. So you get an independent administration by agreement, and it's an independent administrator with will annexed. And that's under, because there's a will, it's under the testate independent administration. Let me see if I can tell you the form number pretty quickly because I have it right here. It's like 6.05 is the application, 6.06 is the order. So you could do it that way. If they can't agree, okay, so you've got a will, but you can't get the agreement of all the devotees because maybe that executor who died was also a devotee. And so you can't get the consent of everyone. That means you cannot have independent. Then you have to go to chapter 11, which is an application for probate of will and for letters of administration. And you have to tweak it because the forms, we don't have like successor applications where the will's already been admitted. So you kind of have to go through manually and pull out asking for the will to be admitted because that part's already been done. But the other part where you're asking for the administration itself, you would do it that way. So, someone's asking the statute of limitations to contest a will. In Texas, it's 2 years, absent fraud. So you can get a tolling of the statute of limitations if you can show general it's extrinsic fraud. So there has to be you have to prove extrinsic fraud to get tolling on that 2-year statute of limitations, but generally it's going to be 2 years. 2 years for statutory bill of review, 4 years for equitable bill of review. The service of citation per 114, the one that takes 42 days for publication. No, it is not that. In the estates code, it's going to trump the rules on that. So it just has to be published one time for 1 day. That's all, not for 4 weeks or anything like that. So don't publish for a super long time. It's a 1 day publish. That's one of the great ones where statute trumps the rule there. When using FedEx, well, I will tell you something about using FedEx as a qualified delivery method. For one, FedEx is not a qualified delivery method, okay? Just like USPS mail is not a qualified delivery method. Registered mail or certified mails, registered mail or certified mail with return receipt requested is a qualified delivery method. And if you look at the Treasury, at the Treasury notice that tells us what's acceptable to the IRS, which is what is acceptable as a qualified delivery method. There's services from FedEx, services from UPS, services from DHL that are considered that. So just be careful. Like, for example, FedEx Saver is not a qualified delivery method, but FedEx 2-day is, FedEx Overnight, FedEx First Overnight, all of those are. So make sure you're using the right service. And what do you do when someone else signs? That's up for the court. The statute doesn't really address that. But generally service is a due process issue. So, that could be a problem. And that may be a reason to consider a 106 motion if you're afraid, because no one wants to do a whole anything and have it snapped undone by a bill of review later. So it may be something to consider, doing something else like a 106 to make sure. I will tell you, well, I also want to be careful on you on that, because when you're saying you're using FedEx to serve heirs, we cannot serve people. Attorneys cannot serve people. So if you can't order a citation and then pop it in FedEx and do that. That is not allowed. I've seen that happen before. That's not allowed. We can't serve writs. We can't serve citation. Only the clerk can serve citation. Harris County, last time I checked, is still not set up to send FedEx or UPS. So if you have to have service by qualified delivery method, you're limited to what the clerk can do. And right now, I think Harris County still is only using certified mail. So I will be honest, and if I'm doing an heirship, I tell my clients it's the same price to have the constable do it or to do certified mail. And we have the constable do it because it's been way more effective because we can't ever get the green cards back. But so if you're serving people, with FedEx, I mean, hopefully that's coming from the clerk and hopefully they're doing all of that right as well. But if it's a notice, like a 308 notice for a will, we are certainly allowed to do FedEx. And that's what we've been doing. We have been doing that. Sending FedEx second day, I think, is like $11.95, and they like take a picture of it at the house. They take all this stuff way better than certified mail. Anyway, so there's that. Looks like someone's asking, is there a remedy if there's only one disinterested witness in an heirship? Wow, I get asked this question all the time. Yeah, the code tells you what to do. You can use the one witness, but courts are extremely hostile to it, and I think for good reason. When I've done it, I will tell you how I do it. I put on a lot. I tell the judge, I will tell him in advance I'm only doing one, and I tell him that I'm fine to come put on my case. And if the court wants to tell me to go away and find more or do whatever, get a genealogist, I'll do it. But I've done it successfully, and I explain every option that we've tried to find a second witness. I would have them go through and say, well, they were friends with this, here were their friends. This is where they went to church. And this person died in this year, and this person died, and this person doesn't live them, and we can't find them. We had a private investigator we put all that evidence on there, and then I do my one witness. And then oftentimes I feel like the court is like, wow, you did a really good job. You tried to find them, and there really only is one. So the statute says that's what they have to take. But you have to show that you really couldn't find another one. And if the ad litem doesn't like it, tell them to put it in their report and set it for a hearing, move on. I mean, it's not their job. It's not the ad litem's job to be judge and jury. They're just supposed to make sure everyone's before the court has been served. All right. So someone else is saying that they're doing a husband and wife, and they both died side by side, same ad litem, same witnesses, same court date. Okay. I mean, they're asking if the post-deceased spouse has been to court, have their estates been to court, and have their administrator accept service or serve by publication. I will tell you, I've had a court not let us do them on the same day because of that reason. I would argue to the court, and this is what I've tried to argue. If you've got husband and wife both died, right, and you're doing heirships. So say wife dies first. So, and then husband dies later. When you're doing husband's estate, there are no post-deceased heirs because maybe it's just the kids. So you can do that. But wife's estate, husband is a post-deceased heir. He survived and then he died, right? If you do last to die first, which is husband, and when you get to the hearing day, you don't really, technically, you don't have service. But as soon as the administrator is appointed and the administrator steps over, he's made it, I mean, they essentially made an appearance. So that means there doesn't need to be service because he made an appearance once he's been, especially once he's been appointed. And there is case law that says, like, if you file like a lawsuit, say you're a surviving spouse and you file a lawsuit on behalf of your deceased spouse and you haven't been appointed yet, but you're pursuing the lawsuit, and then later on, after the lawsuit's almost done, you get appointed. There's courts of appeals that say, yeah, there was a defect in capacity. There was a capacity defect, but it was cured as soon as they were appointed. It was cured. You don't need to tell the district court or tell the court that there was a problem because it was cured, so it's moot. And I think the same thing applies. But I will tell you, it was in Fort Bend. The court made us do the husband first and then get a different day so that the administrator could sign a waiver and come back and do the wife. And sometimes that's just the way you got to do it. Harris County is more, I think, takes a more liberal view of that and basically is like, well, they're going to make an appearance in the proceeding. And you could just put that on your certificate of service that they don't. I would just put, if it were me, I would just put whoever's going to be the administrator of husband's estate has already made an appearance in wife's estate. And as soon as they're based on that other Court of Appeals law, I mean, the defect is cured. Oh, someone asked about the civil rule. It's 114. That's the one that lets you do multiple publications on one citation. It's really, really good. Oh man. So this one, someone's asking, decedent died in 1990, survived by her husband. She had 2 children who predeceased her. Each predeceased child had several children who were alive at the decedent's death. And who do we serve? Well, again, it's the snapshot approach. You go back to 1990 and, like in TXdocs, you can enter in as it was in 1990 and then put in whether they're alive or not. And then if you print the application, it'll tell you who are the heirs and whether they're alive or not. And if all the heirs are dead, then you got to serve them all. But again, that's easy to get confused on. You got to go back to the date of death, see who the heirs are, and then determine if they're alive or dead. If they're alive now, serve them now. If they're dead now, serve them under 51057 as a post-deceased heir. So I know it's hard to get sucked in to thinking about, well, they died and didn't have a will and all of that. As soon as you start saying things like they died and had a will or not, or whatever, you're nesting the heirships together. So you've got to resist the urge to do that. That's not the right answer on how we handle those situations. So someone's asking, yeah, the form of the citation is you go back to they are always noticed when you look at the family, when you look at the heirs when the death occurred, you have to always go back to the time. When you look at that and you see, just like in our example, we looked at everyone who was an heir, and just like in the heirship chart that gets printed out in TXdocs, that's a great way to look at it because you can see who the heirs are and then whether they're alive or dead. And that determines what kind of service they need. Whether they died, whether they're dead now, they were still an heir at the death. They need the type of service that they need. And so if they're dead, the citation needs to be directed to the unknown distributees of that person. So if, in like our Nibbling Ned one, Nibbling Ned was the post-deceased heir. So the citation would say the unknown distributees of Nibbling Ned deceased. You don't look past, you don't do anything with his heirs. You don't go beyond that because Nibbling Ned is the heir in this estate. So we don't go beyond that. We stay in our lane on that. And then
Hey, Joel.
yes.
We're gonna wrap it up.
Okay.
For people who are still waiting for their question, we will answer your questions. We'll send you an email. Joel, I want to thank you so much for your time. This has been great. Everyone who was still here, thank you so much for attending. Please fill out that survey that's going to pop up, and we hope to have you soon on another webinar with TXdocs. Thank you. Bye-bye.
Thank you.